Mr. Bassett.
Good morning, my lords. I appear on behalf of the appellant in this case, along with my learned friend Mr. Rutledge, who sits behind me. My learned friend Miss McGibbon appears on behalf of the respondent local authority. The appellant is here with her instructing solicitor, and I understand her litigation friend is watching on the live link. My lords, this is a rolled up hearing in relation to a proposed second appeal. In those circumstances, obviously to some extent we're in your hands as to how you would like us to proceed. And there is an issue between us as to whether or not the test for a second appeal is met, as far as I understand it. So I can address you on that first, if that would be of assistance.
I think it's easiest if you simply deal with everything together and then we can work out where we are.
That's great.
Mr. Burton, can I just say at the outset, my hearing is not terribly good.
My lord.
If you keep your volume at the current level, there is a risk that I will miss some of your marvellous submissions.
My lord, I'll do my best to both keep them relatively marvellous, but at least loud enough for you to hear them.
And still stopping you getting underway, I've remembered that, of course, there's an anonymity application.
There is indeed, my lord.
Which, in fact, we haven't talked about between ourselves. But yes, as my lord says, so it's probably best if we say now that we will make the order, unless Miss McGibbon has anything. No. And I've seen the draft, and unless my lords have any difficulty themselves with the draft, I would say now that we make an order in those terms.
I'm very grateful. Thank you. My lords, what I proposed to do was just really using the skeleton argument as a template, at least in the first instance, was just remind you of some of the background facts. I'm sure you're familiar with some of them, but I would just like to stress a couple of points, if I can, in relation to those. You'll see they're set out in the skeleton argument from paragraphs 24 onwards. And from there you'll pick up that the appellant has been a secure tenant of her home for some 40 years. She lived there with her two sons, both of whom are adult sons. Her eldest son left many years ago, and her younger son, she contends, of course, left in September 2014. And there is no dispute that at that point in time, the appellant notified the local authority of that fact. Some 3 years later, two council officers visited her property. They were invited inside the property. They came into the kitchen. There was a conversation, as you may have picked up from some of the letters. That was a conversation that the appellant has a particular perspective on as to how it developed. Subsequent to that conversation, where there was an indication that the local authority would speak to some of her neighbours, although I don't believe that actually happened at that time, there was then an investigation opened into whether or not the appellant had committed a form of benefit fraud in this form, but although she'd said her youngest son was no longer living with her, he was in fact living with her. Consequences of that would be that there would normally be a non-dependent deduction applied to her housing benefit, i.e. she would get less housing benefit towards her rent because the assumption is that the other adult living there can make a contribution. Importantly, in August 2017, in relation to an entirely separate matter, the appellant had sought advice from a debt relief agency regarding a debt in relation to council tax. And the short story in relation to that, but it's set out in paragraph 29, is that resulted in a form of debt relief order which effectively extinguished that debt from the appellant's perspective, which had consequences in terms of the amount of money that she no longer owed the local authority. Separately, on the 8th of March 2018, the appellant was then interviewed under caution in relation to the alleged overpayment of housing benefit. She was not accompanied by a solicitor during that interview. During that interview, various documents were, however, presented to the appellant, suggesting that her youngest son was indeed still living at the property, things like letters from banks, etc. Subsequent to that interview under caution, there was then a decision made in October 2018, which resulted in a very significant overpayment on the premise that whilst the appellant had told the local authority that her son no longer lived with her from September 2014, he did in fact live with her for that 4-year period. And of course that generated a very significant overpayment. Ultimately that led to the appellant seeking an appeal, as she had a mandatory right to such an appeal to the first-tier tribunal. The essence of her appeal was that factually that was wrong, that her son, as she had contended, no longer lived with her and hadn't done since she'd notified the local authority of that fact in September 2014. Just pausing there for one moment about the interview under caution. That interview under caution is something that was transcribed. You don't have a copy of it. It might be important just to note that Dr. Kumar did have a copy of that, and it is one of the documents he considered when preparing his expert reports in this case. The parties haven't felt it necessary to include that document in your papers, but I'm just letting you know that it is there, should you take a different view from the parties.
The significant thing that we are told
yes.
is that in that interview she was saying she didn't know where her son was.
That's right. Yes, I mean, it's amongst a number of other things.
Amongst a number of other
That is one point that's picked up, which is then clarified from her perspective at the first hearing at the tribunal when she does explain that she did know where her son was there. Of course, in the witness statement...
In March 20. The first hearing in March 20.
Indeed, yes.
Yeah.
She does explain in her witness statement that, and indeed as does her son, that the circumstances that led to him leaving to the property were not happy ones, that they had fallen out during that period, and that is there as an explanation. But you're absolutely right, my lord, that at that stage she said she didn't know where he was living.
And was that true?
That she didn't know where he was living?
Yeah.
I can't possibly answer that question, my lord. I mean, that goes to the very heart of what this...
No, I mean, was it true that she didn't know where he was?
That's the question I can't answer, my lord. I mean, I don't mean this glibly, that really goes to exactly what this case is about. The ability to extract that type of information from somebody with this particular thought disorder is extremely problematic. Indeed, the first basis upon which the instructing solicitors became concerned was when they tried to take the witness statement. And you've seen the explanation in the letter of instruction to Dr. Kumar about what that exercise was like. And of course, I'm going to take you to Dr. Kumar's report in due course. But we will say that as entirely of a piece with somebody who doesn't really know how to focus on the key information or indeed know how to respond to it. And it won't surprise you, and I may as well say this now, that in my submissions at least, I'm not going to entertain very much speculation about issues that may or may not give rise to credibility questions. The fundamental point that we make here is that during the FTT hearings, the appellant wasn't in a position to put her best case forward, and she should be given that opportunity now, when, of course, somebody assessing her credibility will have the benefit of an expert psychiatrist saying, this is how she's likely to present, and this is what her thought disorder does to her capacity to think, in particular, when under pressure. Of course, that's not the only thing that we say will be different at that hearing. The other principal thing will be the other people who will be coming to court to give evidence and have their credibility assessed in relation to the same question.
Can you just help on a matter of tribunal procedure, which
My lord.
We have been discussing in advance, so I'm not going to tell you what we've been saying.
Of course.
If the rules of evidence are much more flexible.
Indeed.
So my understanding is that in some cases, a witness statement would be put in and no question of calling the witness would arise, and that the witness statement would be accepted, even if it was in some respects controversial.
My lord.
What we're dealing with in the present case is a flat contradiction of what is to be inferred from a large number of documents. So it goes straight to credibility.
Yes.
Are you able to help us as to how tribunals commonly deal with that? Is this a sort of case where if everything were marshalled together, tribunal, first-tier tribunal might say, well, I've read those witness statements, that's all that's going to happen? Or is this the sort of case where one would expect the first-tier tribunal to say, this is a flat dispute of credibility, I've got to hear the witnesses?
The short answer is it would depend, obviously, on all the circumstances. I know that's not necessarily particularly helpful, but if I can explain a little further. It would also depend on the views of both sides, who might be prepared to come up with some accommodations or adjustments to allow somebody to give live evidence, but in a certain way. So one of the cases that's in your bundle, albeit concerning a vulnerable child, speaks to this idea of ground rules in relation to a particular case. If they're going to give live evidence, there would be some ground rules about how that would be done, the setting in which it would be done, the level of formality, the way questions would be asked, would they be open, closed, etc. So there are a number of different approaches that can be adopted. Of course, that's also alongside what other evidence would or is ostensibly available.
Leave aside questions cases where there are questions as to capacity.
Yes.
Suppose an ordinary case where there's a dispute over whether or not housing benefit was overpaid.
Yes.
And the appellant is in person, as I assume is typically the case.
Yes.
How does a tribunal then deal with the dispute? Do you then typically have live evidence, or?
Absolutely, my lord. Yeah, I mean, routinely.
Yeah.
Routinely, there is live questioning. People are asked a number of questions. They're often asked questions principally by the tribunal members, but also sometimes by representatives of other bodies. In this case, a representative of Lambeth would have been entitled to ask questions. Explanations are sought for, apparently contradictory documents or other evidence, etc. But the manner in which a tribunal might approach this question is very flexible, fully accept that. But my lord is absolutely right to highlight that credibility went to the heart of this case in particular, because, of course, leaving aside issues of capacity for a moment, the appellant's case, save with the issue about at what point did she know exactly where her son was living, has been consistent all the way through that he wasn't living there, despite the fact that he was still using the address. Of course, that's not what she focused on when you actually look at the voluminous documents she sends into the tribunal, where she says not a lot more about that, and then an awful lot more about what she thinks is motivating all of this, what's it really about. And we say that goes really to the heart of where the unfairness lies in this case. I'm sure you picked that up from the documents.
Sorry, I interrupted your flow, but that's very helpful, thank you.
In due course, when I come on to what we say are the implications of the error of law, as it's described in the context of the e-jurisdiction, it sometimes seems slightly counterintuitive to call it an error of law. I understand that, because you're not actually criticising anything that was done by the lower tribunal. But insofar as we get to that stage, I will, of course, try to, in a bit more detail, explain what we say the implications of this error actually were in a material sense.
Yeah. So I think we'd allowed you to get as far as the issuing of the appeal.
Yes, and then
probably not much further.
So the way our skeleton works, and I think I'm just going to stick to it, partly because I'm just... I have to say now, I've had a bit of an IT problem this morning where all my bundles have just arrived because my computer might not last the hearing. So I'm just being slightly careful about that. Forgive me. The procedural history is then set out from paragraph 2. And I'm really introducing this by way of opening because I know my learned friend to some extent relies on the procedural history. So in paragraph 2, we again see a repeat of the fact that the investigation led to a decision. Not any criminal charges, I ought to just point out. The appellant appealed, as we said, to the FTT. And at the first hearing of that, which one can see at page 12 of the supplementary bundle, the tribunal judge, Maniara, explained that she was adjourning the appeal in light of what's explained in paragraph 4. and it's acknowledged at that point that she was now able to provide information about where her son was living that she wasn't able to provide in the interview in 2018. And then paragraph 6 recognises at that stage that if council tax bills weren't available in relation to where the son was living, the tribunal would be greatly assisted by hearing your son giving oral evidence. You are therefore encouraged to attend the appeal hearing with him on the next occasion. And to be absolutely frank, this is good, solid case management in relation to a particular person who may have problems generating evidence, and we make no criticism of that at all. On the contrary, and it's also perhaps important to point out that at this hearing, the appellant was actually there in person. She attended, but that is the only time there was any in-person contact between the tribunal and the appellant, because as we know, the ultimate hearing in January 2021 was by telephone. Now, what we also know is that what the appellant did in response to that direction was to send in a number of letters to the tribunal, which we have behind tab 8 in the supplementary bundle.
Well, that comes later. So before you get there, you've got another hearing, and you've got the direction on supplementary bundle 14.
My lord's absolutely right. I do apologise. Yes, you have the August.
There's a further adjournment.
That's right. Sorry, I do apologise.
In July,
August
I think.
July or August 2020. Yeah, my apologies.
I've taken from, I think, from a skeleton.
Yes, no, you're
on the
absolutely
29th
right.
of July,
I,
another FTT judge directed her to produce
Yes, it's on
evidence
the-
by the 20th of August.
Yeah, that's right. It's at page 14 in the supplementary bundle. I do apologise.
And then on the 26th of August, the hearing had to be adjourned because she couldn't be contacted.
That's right. Now, we know at this point in time that she was notionally receiving some help from the advice agency. And in the witness statement that was ultimately prepared on her behalf, she explains that she wasn't hearing anything from them at all about what she was supposed to be doing.
And you've seen the case file? Well, you haven't. If you haven't, your solicitors have.
Yes, they have. And that's, I think, covered in the witness statement that accompanied the application for an extension of time in relation to the appeals. It's demonstrated that, and indeed what was described by the solicitor as a wholesale failure by the advice agency to provide any advice or assistance to the appellant. But my lord, you're absolutely right. I'm sorry I forgot about that further direction that was made in July, and then of course the vacated proposed hearing in August 2020. But what we do know is that letters did then follow after that were written in hand by the appellant. And we've seen those that were available when the parties were agreeing this bundle behind tab 8.
As far as I know, I don't know if others are more privileged. I don't have tabs, but
I'm terribly
it's page
sorry.
15 onwards.
Page 15 onwards. And of course, these are going in at a time where, as I've said, the appellant wasn't receiving any formal kind of assistance or advice. No one's directing her as to what she should be doing. But I freely accept, of course, that in the order itself from Judge Maniara, it suggests what she should be doing. What we don't really know is to what extent that order itself was communicated to her, the extent to which she actually understood its contents, was responding directly to that.
She must have had some communication because she attended the hearing in January 21.
Indeed, and she does say in her draft statement that she was told about that hearing and that she would have to go by herself. Of course, then it turned out to be a telephone hearing. And indeed, when you see some of these letters, you'll see that in due course, I believe, we've got the copies, I think she does cite the appeal number. Yes, for example, at 23, you'll see that a letter written on the 4th of January 2021 cites the reference number at the top. But it's fair to say now, just for the sake of clarity, when we're looking at these, that it's not a key part of the appellant's case that she missed a vital instruction from the tribunal or anything of that kind. It's really about, even if she understood these things, did she know how to respond appropriately? Could she respond appropriately? That's what the expert evidence is directed towards. My lords, I think these letters are, I believe these letters, I submit these letters are important because they are a contemporaneous indication of the mindset of the appellant, and of course they are very important to the expert's opinion. I'm not going to propose reading them out in open court just now unless you would like me to do so, but I would strongly encourage the court to look at those and to digest their contents.
I mean, would you like to take us to an example?
I'm very sorry about my unorthodox presentation this morning.
I always knew that hard copy was better.
16. Yeah, it's been so long since I've had to use any paper in court. It's both aspects.
From my perspective, page 16 is fairly typical.
Yes, so there's a lot of focus on what happened during that first interaction in the visit in 2017. Then there's a focus on whether or not the officers from the council have been telling the truth and whether or not they were committing offences of that kind. I will help you with page numbers in one moment. Then you see the first link to the issues around the debt relief order at page 21. But even at 18, you do see that the fairly typical also includes this sense of indignation that somebody would claim that she would have her son live with her just to make a financial gain. And that sense of being criminalised is evident throughout a lot of these letters. The letter at page 19 is the one about the Lambeth officer committing offences. At 20 again underscoring that her son is neither a criminal either, merely because he didn't change his address. And then at 21, we see the first reference to the chronology as she sees it and the connection between the debt relief order and the visit to her home. And then at 23, the letter to the judge, thanking the judge for giving her the opportunity to provide all of this evidence. So she thinks she's doing what's required of her, whether specifically in relation to the order made in March 2020 or not, we don't know for certain. And then at 24, again, we see reference to life not being made easy after the debt relief order.
But there are two things about these letters which I'd be grateful for your help on.
Lord.
One is a suspicion that First Tier Tribunal, particularly Social Entitlement Chamber, these sort of letters are probably not unique.
Mm.
That's the first thing.
Yeah.
The second thing, which I'm sure you're coming to, is Dr. Kumar, from his perspective, sees them as supportive of his diagnosis of delusional disorder.
Indicative, yeah.
So in a way, it almost doesn't matter what we think about them.
I agree. My main point really is the timing of them. Because the real issue between us here is, did Dr. Kumar do enough to get over the threshold to make it effectively untenable to suggest that the condition she was suffering from in November 2021, that in his opinion rendered her incapable of conducting legal proceedings, was present in January 2021, if not earlier. And he relies on these letters and, of course, his interviews and assessments of the appellant herself to draw that conclusion ultimately in his first addendum to his report. But as my learned friend absolutely fairly identifies, that report has come after the hearing before the district judge, which is the subject of this appeal. No doubt at all Dr. Kumar's opinion now is that she lacked capacity at the material time. The difficulty is, in his first report, he wasn't asked specifically that question, although it will...
And you're not submitting that the first tier tribunal, or you haven't yet submitted, that the first tier tribunal should have been on red alert, to use the phrase.
Absolutely not, on the contrary.
So, which ties in with what I was asking about these sort of letters not
Absolutely.
being unique.
No, and I it's a very, if I may say so, a very insightful question, because they are so typical that they don't have that sort of consequence. And indeed, if I can put my submission this way, the way the deputy judge dealt with this in the upper tribunal when he dismissed the appeal was, in my submission, to effectively say, well, as a response to these letters, appropriate steps were taken, in the sense that it was recognised that she had this apparently genuine belief about what the problem was, and that steps had been taken in the proceedings to give her every opportunity to respond. But that completely misses the point about what Dr. Kumar's actually saying. It's not that she couldn't understand, it's that she couldn't then respond appropriately. Because, as the way he puts it, her thoughts stop working effectively when she gets into this stress state where she's deeply paranoid about the circumstances that have given rise to this legal issue, which is entirely consistent with what impression the solicitors formed when they were trying to take a statement and then ultimately sought his opinion. So presentationally, it doesn't look that out of the ordinary. But with the diagnosis of the thought disorder, it takes the case completely out of that. But the straight answer to the question is we don't criticise the tribunal for anything it did at this stage, because it was in the dark about the key issue.
And on that basis, the conclusion the FTC came to is predictable.
Absolutely, yeah. Almost unavoidable, frankly. I mean, perhaps it would have been different if the only other difference was she was in the room with the tribunal, and they could have reached a different conclusion about her presentation when giving evidence. I mean, that's not inconceivable, because that's exactly what happened, frankly, with her solicitors. But we never got to that stage. There was a telephone hearing, I accept. But whether or not that would have been sufficient to alert the tribunal that something wasn't quite right. And the case law is very clear, and I'm sure it's not disputed, that if the tribunal did have cause for concern about capacity, there would have been a duty on it to investigate. That duty passes to any representatives once you are represented, of course. But when they're not represented, then the duty lies with the tribunal. But it really is only when you understand where this is coming from and the underlying thought disorder, in my submission, that you can see these letters in the way that Dr. Kumar does. And once you do, you start to see her entire response to the appeal in this way, then you can see where the risk of unfairness lies, or the risk of an injustice arises. So, and just to finish off on the letters, by 18th of January, at letter 27, I mean, it's absolutely explicit. She's saying all of this is a consequence of me having got the debt written off. So she's accusatory of the officers from the council, believes that she's done enough to explain the circumstances, that her son continued to use her address, and is completely convinced to the point that that's the only thing she's writing about before the hearing, that this is all motivated by something that she did which was contrary to Lambeth's interests. There's a sort of tenable logic to it all, but it's the kind of thing one sees in paranoid individuals, and that's exactly how Dr. Kumar ultimately sees it. So if we now can turn up Dr. Kumar's report, please. So that begins at page 68 of the supplementary manual. The upper tribunal judge doesn't ultimately accept, or at least cast doubt on, some of Dr. Kumar's conclusions. I'm not sure the extent to which my learned friend really relies upon those, but it might be just important to note his credentials, which are set out under heading 1 and 1.1, the writer. Obviously, a very well-established consultant psychiatrist for many years, with particular focus on psychotic and mood disorders, and an interest in cognitive deficits and psychotic illness. In terms of the instructions at 1.3.1, obviously there's the first one, which is about the extent to which there is a mental impairment. The second one addresses whether or not it's been present for 12 months, because that reflects the test in the Equality Act for a disability, which is then referenced explicitly in 3. 4, what would the likely effect on the mental health of the defendant be of having to leave her property? That's because this report is being prepared in anticipation of possession proceedings being taken against the appellant. 5, what would be available in terms of treatment? Sorry, 6, what would be available in terms of treatment? And then the capacity question, which is specific to legal proceedings, and the only legal proceedings at that stage are the tribunal proceedings, and it becomes apparent when you look at the instructions that those are the proceedings that have been referred to and ultimately in the statement. At 2, the expert acknowledges that his facts are coming from the instructions he's had from the solicitor, and he's very clear about that. And they are set out there. Paragraph 2.2.8, you'll see the reiteration of what the solicitors had told Dr. Kumar about the difficulties they had trying to get a witness statement from the appellant. At 2, footnote 2 at the top of page 76, he clarifies that these are the only matters he's been asked, and the fact he hasn't said something does not mean he has no opinion on the issue.
Sorry, where are you?
At the top of page 76.
Got it. Yeah.
He then deals with methodology. I don't think I need to take you through that. Then at paragraph 3.2, confirmation that there is the interview and examination. Paragraph 3.3, the document. It's common ground that he was looking, amongst other things, at the letters that we saw, but also the interview, the transcript of the interview under caution. He also confirms at paragraph 4.41 and elsewhere, as we will go on to see, that he also had full medical notes. He then takes at 4.2 onwards a very extensive family history, which we will see is not irrelevant to the findings he ultimately makes.
Why do you say that?
Because what he goes on to say later, effectively, is that she forms impressions about her past that don't seem to be objectively verified. For example, she says her latest partner was good to her, whereas the evidence that Dr. Kumar saw would suggest very much wasn't the case. She made claims about the extent to which he was successful at school. Again, he thought that was unlikely in what he was being presented with. It's an insight question which he ultimately deals with, or the lack of. There's also an extensive part of the report from 4.6. There is in the report an extensive physical history, which again, it's also not unrelated to the conditions he ultimately finds, which is, as we'll come on to see, and I'm sorry this is not as clear as it might be, my computer's really not behaving. What we see ultimately in the report is that she has stomach issues, serious stomach issues, which don't appear to have any organic source, which ultimately leads to one of his diagnoses. Then at paragraph 4.8 is the discussion around the housing issues. And how they were conveyed to him by the appellant during his assessment. And the firmness with which she asserted what we've already seen from the letters, that this all started with her actions in 2017, but that everything that she was saying about the housing issues was, as he says, difficult to follow, partly because of how emotional she became and how convinced she was that she'd been treated badly. And then goes through the history of the officers coming to visit her, etc. A concern that they were checking with neighbours, but had come into her house and not even checked his bedroom to see if there was any evidence of him being there. And then, for example, the end of paragraph 4.8.5, she said she cannot be held responsible for her son not changing address with some of the company he was getting letters from, and they could not use it against her. So things took a turn from bad to worse. So that sense of indignation and being treated unfairly, rather than just being able to see it for what it was, that there was an evidence problem that she needed to address. And Dr. Kumar introduces his own comments about that. At 4.8.6, and the lack of a coherent explanation. And then at 4.8.8, you really start to see the degree of confusion here. She says that in 2019, she'd actually told them she did have somebody living in the property, a lodger. And again repeats that it's unfair because it's not her responsibility to take control of what her son does. And then effectively, a clear indication she just doesn't understand why, having got the debt relief order, she owes any money to Lambeth.
I mean, in one sense, what we think about all this doesn't matter, as my lord says. But that's not obviously irrational. If you get a debt relief order, you might think, well, that's the end of all my debts.
Yes, but she can't, she's seeing all of this as being about, she understands the difference between council tax and her rent, it would seem. She says as much. And she clearly, in the letters that we've seen here, and as Dr. Kumar goes on to say, says that this is persecutory, as in that it's because she obtained that relief that Lambeth have taken the action they have in relation to her son no longer living there, which she cannot understand because she's told them that he's not living there. And then gets cross that when they come, they don't come upstairs to look. They want to talk to her neighbours. She's been there for 35 years. She's obviously, as she says there, has friends in the area. And obviously, as we go on to see, that when she had solicitors able to mediate all of this, then these neighbours and others were approached and they were able to assist her demonstrate the truth of what she was saying. But that's not her concern at this stage. Sorry.
This obviously comes filtered through Dr. Kumar, and as he explains, it was difficult to follow what he was being told.
Yeah.
But as filtered by him again in the second sentence, the appellant said that the court ruled that she had to provide proof that her son moved out, but she thinks that was unfair. I mean, that, on the face of it, that suggests she knew what the court had required of her, but she didn't think she ought to be doing it. Well, again, that's not an obviously mad position.
Well, my lord, I don't think anyone's thought disorder of this type is one that it's getting in the way of her ability to see this for what it is and respond appropriately. She wants to respond in a certain way, as we'll go on to see when he explains what he thinks implications of this are and why it's a formally recognisable disorder. But I don't think there's any avoiding the fact that we are dealing here with a highly unusual presentation. And we're all tempted to read this and think, well, this could be perfectly consistent with somebody who just doesn't want to face up to what they're being challenged about. This is a diversionary tactic in order to avoid the implications of having to tell the truth. Dr. Kumar could very well have reached that conclusion, but he very squarely doesn't. And we have to then look at what was eventually done on the claimant, on the appellant's behalf, once she was put in a position to have the assistance that she was otherwise never given. Have to look at it that way. That's where the doubt comes in. It wouldn't stop, of course, a tribunal ultimately looking at all of this and still saying, well, we still think you're lying. But that tribunal would only be able to reach that decision fairly if they've got Dr. Kumar's opinion, or a different one if Lambeth want to reduce one.
Or if, which you're not asserting here, the content of the letters or the reaction was such as to put the tribunal on red alert.
Yes. I mean, that...
But on the facts of which we have to be conscious of, because this is a second appeal.
Yes.
And part of the justification, if we give leave, is that it has wider implications than this case.
Yes.
So when you said a few minutes ago, of course, if they're alerted to potential lack of capacity, they have a duty to investigate.
Yes.
The critical thing is if.
Yes.
If what should you do if?
There's no doubt that's true, but that's not a cornerstone of my case.
No,
here.
I understand that.
What is ultimately what I say would have been the case is had they been made alerted to the lack of capacity, there would have been this ground rules approach to how the hearing should be conducted. So that's process. And there certainly would have been an understanding that any evidence she did give, orally or by other means, would have to be looked at through the prism of what Dr. Kumar is saying about her capacity to respond. And the tribunal then would have been able to reach a fair decision having regard to all of that material. And of course, as I'm going to say again, but I don't want to repeat myself, it's not just about what she would have done. I mean, what's missing from all of this is any indication that if she doesn't feel she has to explain her son, why isn't her son coming to help explain on his behalf? You know, why aren't neighbours coming forward? Because she doesn't understand that she needs to do that. Because she's indignant about the very idea. Because it's not about her son not living there, it's about the fact that she got the debt relief order. But ultimately, in answer to my Lord Justice Newey's question about, to a certain extent, doesn't matter what we think about this, I agree, which is why I didn't want to answer the question, because I haven't frankly asked it about what was true or not about what she knew initially. All of this has to go into the assessment. But there is then at 4.10 the mental state examination, which again is extensive and thorough. I won't take you through all of it. But in addition to identifying the degree of thought disorder with circumstantiality and tangentiality, it's made it difficult to follow her conversation. At 4.10.4, Dr. Kumar also references the paranoid beliefs and how that meant she looked at everything in a very self-referential way. I couldn't look at it objectively.
What does self-referential mean?
Well, that's how I understand that to mean. It means there's no ability to come out of their own understanding of the situation, no ability to look at it objectively and say, well, maybe Lambeth are presented with material and have got a legitimate question to ask. Or even moreover, why aren't you responding in the way that you've been asked to? You can't see it that way. I'm slightly foreshadowing what Dr. Kumar ultimately goes on to say. But you see then in the cognitive functions, she also did badly on that. But partly because Dr. Kumar thinks she wasn't really trying, didn't want to participate.
That's quite an odd feature, isn't it? I mean, there are psychometric tests which are designed to identify whether someone is deliberately not trying or not trying. We're not in that territory here.
No, and there are also clear tests or scores for establishing more orthodox forms of cognitive impairment, which Dr. Kumar goes on to talk about. So it doesn't present in that way, although he's concerned enough to suggest there needs to be an investigation for whether there are any organic causes. And he goes on to list what some of those might be. And you see at 4.10.11 how he summarises that. And then at 4.10.12, that the appellant doesn't have any insight about it. And then we see an extensive assessment of the medical records, which is largely focused on the particular physical issue I already mentioned a moment ago. So again, I'm not going to read out in open court at this stage, but it's there and forms part of the ultimate conclusions reached.
Is it fair to say that there is some evidence of psychiatric disorder from time to time, depression, stress, and so forth, but there's no suggestion in the medical records of any thought disorder?
No, exactly. That would be correct. Save to the extent to which ultimately Dr. Kumar identifies a form of thought disorder in terms of the subconscious relationship between stress and the gastro. And then at 4.12, as again I foreshadowed, there's Dr. Kumar's assessment of the letters. Now, I just need to pause here for a moment because yesterday, in response to a question from the court, there was an inquiry as to what letters were out there, effectively, that had been written by the appellant. There's the ones in the bundle behind tab 8. There's then some letters that have been produced by the respondent, which were sent to the respondent by the tribunal, which, as I understand it, were included in all the material that went to Dr. Kumar. And you will see some references in here to letters that don't actually appear to be in tab 8, but do appear to be in that bundle. So certainly it would appear that Dr. Kumar has seen everything that was available. There's no suggestion that any documents that exist were not seen.
It's not specific about a letter from the mother. The letter that can't be traced.
From the appellant's mother.
From the appellant's
No.
mother. So at the moment, that is untraced, and we don't know where it went. Or
No, we don't. We don't know if one ever existed, or whether it may have even been a mistake in the way the matter was recorded by the first tier tribunal, or if one existed, nobody's been able to find it. But there's a detailed examination of those letters, and then at 4.12.6. He says there are many similar letters, and most of them are filled with her anger and distress at being accused of not informing the council about her son moving out and all that. And it does have a paranoid flavour all the time. And then at 4.12.7, confirmation that he's read the recorded interview, and that's the interview under caution. So opinion is what we look at next. And I'm going to do it this way, if I may. If we go to 5.120, which is at page 104, which is an answer to the last question, question 7, does Ms. Plummer have capacity within the meaning of the Mental Capacity Act without legal proceeding? He acknowledges that she understands the proceedings, understands the court processes, understands the consequences. When she's stressed, she becomes quite overwhelmed by it, and then her paranoid beliefs about the investigators trying to get her out of the property become strong. She also would find it difficult to give clear answers to questions, which is what the solicitor struggled with. So it would be difficult for the solicitor to get instructions from her when she's overwhelmed by stress, as her cognitive functions would be significantly impaired. She would struggle to recollect, she would struggle to understand, and she would struggle to retain when under stress. And then her paranoid belief system would become prominent. She would start thinking that people were deliberately causing her all of this distress because the Christians Against Poverty charity organisation had helped her with debt relief in the past, and the council did not like it. So although she's able to understand what the court case involves in the legal procedure, her explanation for why it happened to her is driven by paranoid beliefs about Lambeth Council trying to get her out because she made them lose money or get debt written off. That paranoid belief also is triggered by the stress. As mentioned earlier, with her cognitive impairment during stress, she would struggle to fully understand the evidence and give appropriate instructions. This is very evident in all the letters she wrote and the interviews that she had. And then in terms of summary of conclusions, the expert identifies the two disorders, the gastrointestinal system and a condition called other dissociative disorders. And then he says at 6.2 that they're major mental illnesses, all of which are long-term, and they significantly impact on her level of functioning adversely. So the summary there suggests a clear link between, the summary there sets out what the disorders are and that their long-term nature. But to find out a little bit more on the focus of the Upper Tribunal's judge's conclusion, we look at 5.1.14, which is where the expert was answering the question about whether or not these impairments have existed for 12 months or more.
I suppose, sorry, I'm being a bit slow. What comes out of the analysis you've given us is that the letters themselves are manifestations of her difficulties.
That's exactly how the expert sees it, yes.
Yes.
Indicative of it.
And so on that basis alone, or it may not be alone, but on that basis alone, you would say that Dr. Kumar is evidently talking about the period before the 28th of January 2021.
Absolutely. And he
It's being a bit slow.
And at all points he is doing exactly that, and then confirms as much in 5.1.14, but in a very fair way acknowledging the difficulties that he has in identifying just how long, in particular the Ganser syndrome, has existed, which is the one which, actually I'm taking you out of, I think here, because I think it,
He explains that in 5.1.10.
yeah, exactly. I'm very sorry. I should have taken you there first. But that's where he actually explains what that syndrome is, and of course we need to see that and understand it.
And he's backed off that now.
Well, no, he's backed off.
It's not Ganser.
It's not Ganser, no.
But it's
It's a delusional disorder.
Yeah.
Yeah. Having seen her twice and seen all of that material. So sorry, the reference is 5.1.10, my lords. It explains what the consequences of that are and the giving of approximate answers. And how that relates to the apparent cognitive impairments, and then his difficulty in identifying what the well, his indication that there may still be an organic source for that, and he can't rule that out.
So it seems that she lacks capacity to conduct these proceedings. It's the situation in relation to her housing which has caused this disorder. So she could
stress around it, yeah.
Exactly.
That's what he says is causative, yeah.
Exactly.
That's the
So
etiology.
she might be able to conduct other legal proceedings about other things, but this particular situation causes her to lose capacity.
Yes, and whether or not the inclination to find if you like, a persecutory reason would always be there, or whether it's particularly linked to here isn't abundantly clear. But what is clear is that the expert is confirming a lack of capacity in relation to her ability to conduct legal proceedings at a time where, in relation to a diagnosis of disorders, which he's prepared to say what he says on page 114, which is the certificate of capacity.
But both the certificate and this first report are written immediately in the context of the possession proceedings.
But there aren't actually possession proceedings at that stage yet.
Notice of intention.
There's a notice indeed. But it's right to say that one cannot necessarily easily distinguish between which ones he's referring to, except that when you look at the letter of instructions he's reading from the solicitors, that is going through all of the proceedings in relation to the housing benefit overpayment. And of course, the link between the housing benefit overpayment and the possession case is inextricable, certainly from the appellant's perspective. The reason why her home is being threatened is because of the overpayment issue. The determination to get her out of the house is manifest in this unfair allegation that her son continues to live with her, so she can make a 25% saving on her rent, as she puts it. So they're indistinguishable in that regard. Where there might be a question, to be frank about it, is would there be any scope for a different approach in those two different proceedings to the question of the consequences of capacity? Because the possession proceedings don't take place in a tribunal, they take place in a county court. And I fully acknowledge that. Where we get into the stage of what necessarily the implications would be, because in the county court it certainly would be a litigation friend, but in the tribunal it might not be. But it might be some other measures taken to address the same underlying problem.
So just to be clear, if you go back to 113, one sees that the proceedings are identified as potential possession proceedings, but as you say, there's no reason why the appellant or Dr. Kumar should have distinguished between the two. They were tied together.
No, and the question of substance is really what I'm trying to bring us back to, which is what he's considering in the letter of instruction, the background facts. What he's asking her about in terms of the hearings and what she's told about judges, what letters he's looking at are all in relation to the tribunal proceedings. Nothing he looks at concerns the possession proceedings, because there isn't anything in that stage. But it's formally right to say that that's how it's headed at the top of the form.
Yeah.
It's also right to say that you get, because this is addressing capacity specifically, rather than the report which addressed a number of those different questions, you get a little bit more detail from Dr. Kumar about his thoughts or his opinion, ultimately, in relation to capacity. As I've already said, at box 2 on page 114, he identifies the relevant disorders and also how long they've lasted for. So in relation to the dissociative disorder, he says since 2018, approximately. And then you see at box 3, my lord, specific reference to the tribunal proceedings in relation to the overpayment. And then rather than me read it out, if I could just invite the court to read how he then addresses the following boxes, which are the substance of his opinion. And so it's really, for the purposes of this appeal, really important how he addresses the last of those, the ability to weigh information, part of the process, and making decisions in the conduct of proceedings. Because having acknowledged that she can understand quite a lot, to summarise, the fixed paranoid beliefs, to a manifestation of the thought disorder, interfere with her ability to make decisions.
Where are you?
So, first box at the top of page 115, where he's ticked, he or she is unable to use or weigh the following information as part of the process of making decisions. My lord, it's slightly unfair of me not to highlight that these boxes all reflect the capacity test and the different components of it, which is he's addressing. Now, it's also important to keep in mind that at the moment he understands her to be represented by solicitors, so he will reference the difficulty she has even giving them instructions. But it's effectively a for sure, if you can say such a thing in relation to opinions, as to how she'd be able to respond by herself, which of course is how she was having to carry out the tribunal proceedings hitherto. And again, he repeats in support ultimately of his conclusion about how long she's had these disorders, and therefore lacks capacity. The last sentence, last two sentences of that box, this is very evident in all the letters she wrote and the interviews she had. She found it difficult to view the information available to her objectively, weigh the pros and cons, to make decisions and give clear instructions, despite having a degree of understanding about the proceedings beyond that. So I'm moving rather slowly, and I'm sorry about that. It's difficulty I'm having presenting the case this morning, for which I'm sorry. But coming back to the skeleton, what the solicitors then do...
Do we need the supplemental bundle anymore, or shall we put it away?
We will have to come back to it in due course, my lord, yes. We're actually still in here, the procedural history.
Yep.
As I said, it's of some importance, not least because we need to be aware of what the wider implications of this appeal may entail. But there was, in first instance, an application to set aside the decision of the tribunal, which I actually appreciate we haven't actually looked at yet, but we should do so, which is in the core bundle, which is at page 123, behind tab 17. Confirmation of the decision on page 123. She's been overpaid housing benefit because her non-dependent son resides in the property. Summary of reasons. And at paragraphs 8, 9 and 10 you see effectively, actually going all the way through to 14, you see the evidence that was adduced by the local authority. At this stage I'm not going to say anything about that, but if my learned friend does seek to rely on it to an extent, I may make a few points about it. But what we'll go on to see is that one point that was considered to be of particular significance to the fact-finding tribunal, of course unaware at this stage about the capacity issues, is that evidence came from the son's employer that he still used that the only address they had for him was his mother's address, which does appear to be correct, but it also seems to be correct that that job started before he left his mother's address. It's just an important point to highlight. He started that job in 2014 and didn't leave home until later on that year. But it certainly seems to be the case that he didn't give them a different address at any point. Otherwise, it's really material of a piece. It's bank statements and such like, which are still suggesting he lives there, although she would say covered by the fact that her son continued to use the address. And then we've got paragraph 15. I find that the local authority has given numerous opportunities to Miss Plummer to provide evidence of her son's residence for the period of the overpayment. And then at paragraph 16, indicates that the tribunal also gave her that opportunity. And that at paragraph 17, the only response that's noted there is that she provided 2 handwritten letters prepared by her and signed by her son, stating that her son lived in Streatham, etc., and that there's an absence of any independent evidence. What's unclear, to me at least at this stage, is whether or not the tribunal had had sight of, when making this decision, all the other letters that we've been looked at. That clearly the tribunal had, because they're the ones who sent them back to us. But they're not specifically referred to.
They say, the decision says I've had regard to the letters dated 1st of December, 4th of January and 21st of January. It's paragraph 3.
I'm most grateful, thank you.
But you're right in the sense that there's no express reference to 24th of November 2020.
No, and no reference to them in the actual reasoning. We only see what's said at paragraph 17 about the letters that were handed up before the hearing.
And just to be clear, of course, there's a later, fuller explanation from
In
the
the statement of
tribunal,
reasons, yeah.
but the picture is the same, you say.
Yeah. And then we see the conclusion at paragraph 18, which is a finding that it would be a relatively straightforward and simple matter for Miss Plummer to be able to show that her son resided in Streatham during the overpayment period and that he now resides in Enfield. Such evidence could take the form of electoral register forms, the absence of council tax bills, tenancy agreements or other bills addressed to her son in Streatham or Enfield. The fact that Miss Plummer's son is not listed on the electoral register at her address is not of sufficient cogency to displace the other evidence that shows that he was linked to her address during the period covered by the overpayment. It seems fairly clear that it was Lambeth that told the tribunal that the son wasn't registered at her address for electoral roll purposes. That didn't come from the appellant. But it's, of course, just one feature of the evidence that they're considering at that stage. So that ultimately led to, as I say, the application to the solicitors who were then instructed in relation to the putative housing proceedings, and then ultimately made a set-aside application to the tribunal in relation to the findings made in January. And we see that at page 111 in the call bundle. And it comes in the form of a letter. And the matter that became immediately apparent as set out in paragraph 2 is the connection between the overpayment proceedings and the putative possession proceedings. A number of observations are made about the inquiry that was conducted by Lambeth and the indication that the client had told them about the lodger. And then an explanation of the understanding from the client about what Centre 70, the advice agency, did or did not do. And then at the third paragraph, an instruction that she was not able to provide the independent evidence as her son, despite leaving the property in September 2014, still kept his address as that of our clients, and that he never formally registered his new addresses. So an explanation about the very material that the tribunal had relied upon as being indicative of her son still living there. A reflection of the client's instructions as to how the hearing in January 2021 over the telephone was carried out. An indication that while Centre 70 have asked for permission to, have sought an appeal, they don't understand how there could be an appeal because, of course, they didn't have the relevant information. And then at the final paragraph on that page, perplexed as to the complete absence of any advice or assistance from 70. Which they say is supported by the fact that Centre 70 would like to issue an appeal but haven't identified any error of law. And in their view, as solicitors, but housing solicitors, not benefit solicitors, it might be important to point out, Centre 70 completely let her down. Confirmation at that point that it's not in scope, they've got no legal aid to assist the appellant in relation to these proceedings, but nevertheless have undertaken some of their own inquiries and have spoken to the client's son. And there we see a substantive explanation on the first point of contact with the son, explaining why the situation was as found by Lambeth during the investigation, and confirming that a signed witness statement from the son was now available. They've also contacted the landlords, and the solicitors directly, and have sought the confirmation that has come in the form of 2 signed letters that are exhibited to the son's witness statement.
Can you help about that? Because in the index to the supplementary bundle, 11, 12 and 13,
Yes.
sorry, 10, 11, 12, 13, are the witness statements which were clearly taken by G.T. Stewart, the solicitors.
Yes, my lord.
And in the index it says, sent to the First Tier Tribunal.
Yes.
They're all dated 17th or another date in September 21. So that must mean the set-aside application.
Yes.
I wasn't able to identify exactly when they were sent. Do you know?
My understanding is that they were actually sent with this letter, is that right? Yeah, they were attached to this letter. But I agree, it doesn't actually say anywhere as clearly as it might that that was the case.
No, because the letter to Dr. Kumar identifies what they sent him,
Yes.
but this letter doesn't.
No, I agree.
And it's a slightly odd phraseology when they say, you know, what they don't say is,
Here it is.
here it is.
Yeah, no, I agree. But I believe it's common ground that that's what happened. The letters were
Anyway,
sent.
but it's not in dispute that before the set-aside application was
No,
decided,
I fully acknowledge that. Yeah, as I
10
understand
to
it. 13.
tabs 10 to 13,
Yes.
those letters were
Yes.
before. Yeah, okay, thanks.
What also happened, of course, is that in that letter they indicated they had concerns about capacity. We're in the process of obtaining psychiatric report. And then on the 13th of December 2021, the appellant solicitor forwarded the capacity to conduct legal proceedings the certificate that we've just been looking at. I'm most grateful to my learned friend. 114.
They're acknowledged in the letter from the tribunal.
I think it's quite, I submit, it is common ground that these documents were provided with the letter. We've got no real indication that they weren't. My learned friend has pointed out that at page 114, there is reference to documents being attached.
Sorry, I haven't spotted that. Where do I see that? Oh, I see documents attached. Yeah. As the documents attached.
And it's just before the paragraph about concerns about capacity. And certainly I'm making my submissions on the premise that those documents were seen by...
But then that's common ground.
Yeah.
Yeah, thank
you. We then see the refusal to set aside at page 109 in the core bundle. Now, I don't think it matters too much at the moment, but not being welfare benefit solicitors, the way they put the set-aside application was clearly on a false basis, which was that documents that could have been seen by the first-tier tribunal were not, on the premise that they existed at that time, and when they didn't, they must be the witness statements. But the actual reason for the dismissal, in first instance, is time. The first-tier tribunal said that the month time limit for seeking a set-aside had not been complied with. And we see that paragraph 4 on page 109, by reference to the fact that she was at all times represented by a specialist welfare rights organisation and or solicitor. I don't need to trouble you with that just now, because ultimately the upper tribunal took a different view about time and agreed to extend time. But then at paragraph 5, there's the point I made a moment ago, that the application was considered to be misguided in any event. And then on capacity, we see 2 points. First of all, paragraph 6, we see that she's the evidence is based upon an examination that took place many months after, on 29th of January 2021. Doesn't actually engage with the fact that the certificate says that the conditions that led to the finding of that capacity had pre-existed that. And then at paragraph 7, the district tribunal judge said that she listened to the transcript of the hearing and noted that Mrs. Plummer was able to answer questions and engage with the issues in the appeal. And then notes that she doesn't at that point have an appointee dealing with her benefits. The inference therefore being that she presents as capable of managing her own affairs.
So, I mean, putting the two paragraphs together, what the judge is saying is, look, I've got a doctor's report, but it's based on things that happened rather later. And I've actually gone back and listened to the tape, and I can hear that there was a perfectly coherent conversation.
Yeah.
Now, was that not an appropriate approach?
No, in my submission it wasn't. First of all, because on the first question, as I understand, she has a certificate at that stage saying lapse capacity, which clearly demonstrates that the conditions that cause a lack of capacity are identified by the experts having pre-existed the proceedings altogether, and certainly the January hearing. So at this point, it would be very open to a tribunal judge, perhaps one who hadn't already dismissed it on the grounds that it was late, to say, well, this evidence about capacity isn't complete. Because, of course, if she had seen Dr. Kumar's report, he's very explicit that he hasn't been asked the question, and he shouldn't be presumed to have an answer on it simply because he doesn't give an opinion on it. But the capacity certificate itself is more than enough to put anyone on notice that it's at least likely that she lacked capacity earlier than the date of the assessment, because the conditions that led to the conclusion that she lacked capacity pre-existed those.
So just to be clear, I'm not sure how far you say this decision matters. Maybe you say the decision doesn't matter. But supposing the decision does matter,
yes,
is it your position that the judge was not entitled, having regard to the expert report and having listened to the tape, to conclude that the appellant had capacity in January.
I'm not. I mean, insofar as that's the decision, I wouldn't necessarily read this as saying that the tribunal judge has actually found that she did have capacity in January. The finding appears to be that she presents as capable of managing her own affairs, which is a different test, as the court will be well aware. It's not the same as having capacity to conduct legal proceedings. As we will see when we look at one of the cases, the Court of Appeal have previously expressed significant disquiet about a judge looking back retrospectively at a hearing, having been subsequently notified of a lack of capacity, and saying, well, it all looked fine to me. In other words, they appear to be engaging. That's before you even get onto the substance of what Dr. Kumar actually says, which she may appear to be understanding, she may appear to be engaging, but she can't respond appropriately.
But maybe the judge thought she was responding appropriately. I mean, she listened to the tape. She says that the appellant was able to answer questions and engage with the issues.
Yeah. Well, had it been necessary to challenge that decision, and there's a history in relation to that, because the first application for permission to appeal addresses both this decision and indeed the primary decision of the tribunal, and says they're both unlawful by reference to the capacity issues. So to that extent, it would have been challenged were it not for the fact that events have been superseded and we're now challenging the upper tribunal's decision. So,
yes, I see.
So there's a limit to how much I can really engage with why I say this is unlawful. My learned friend relies on it as being an indication that nothing would have changed even if the upper tribunal had taken a different view about capacity, because the consequences would have been the same as this, effectively. Well, I would hope to persuade the court of a different opinion, which is that it's simply not possible to listen back to the tape and say, well, despite the expert's report, I'm concluding that...
But it's not despite. It's a two-pronged argument. One, Kumar does not cover January.
Yes, no, I understand that. Yeah.
Two, given that Kumar doesn't cover January, I've listened,
yeah,
and it sounds okay to me.
Mm-hmm.
That is not the way that an argument could be framed if the first proposition is Kumar does cover January.
Yeah, save for the fact that...
Because then you get into your authority, whichever it is.
I fully understand, yeah.
Don't go and try and contradict an expert by just listening to the tape.
I agree. But if you're going to then have regard to that evidence about her capacity at that time, you should also have regard to what Dr. Kumar says about that. Now, he doesn't give a clear... I absolutely agree. I have to accept that at that stage, there's no unequivocal statement from Dr. Kumar that she lacked capacity in January 2021. But what he does do is give a very clear indication that she may have done, and you've got to then weigh that up against the other evidence. And it does seem, in my submission, there's something extremely difficult about a different judge listening back to a tape recording and saying that I've found that you have capacity then, when I've got an expert saying you don't have it now in relation to conditions that you did have then. All of that would have to be weighed in the balance. And were I attacking that decision openly, then that's certainly where my submissions would be directed.
So in summary, you say, well, the actual ground for the decision was about time.
Yes.
Anyway, who cares what this judge thought? That's not what's at issue. And so far as what is said about capacity, if indeed it is about capacity, is concerned, there is no actual finding that there was capacity in January. And if one did read it as a finding that there was capacity in January, that doesn't really fit with Dr. Kumar.
Well, it would certainly doesn't seem to acknowledge what Dr. Kumar has said and factor that in to the consideration. So,
is that fair? Because 6 does refer to the production of supporting evidence and indeed refers to when the examination took place.
Well, exactly, but that's only the examination. I mean, I cannot get around the fact. I don't want to try to be seen to be avoiding it. Dr. Kumar in his first report is not asked and therefore does not say did she lack capacity in January 2021. The highest that evidence gets to is the reasons why he found she lacked capacity in November 2021 were clearly present in January 2021. And the letters that he used to support his findings were all contemporaneous with that hearing. And so just taking a step back, any common sense analysis of that material is going to say, well, clearly a very strong reason to believe she may have lacked capacity in January 2021, would such a belief be satisfactorily dislodged by, frankly, a lay judge listening back to the hearing, of a telephone hearing, saying, well, it seems okay to me? In my submission, no. One would have to take a much more cautious approach to such a significant issue as capacity to conduct legal proceedings. And in one of the cases I'm going to show you in due course, that is the approach that the Court of Appeal took. Lord Justice Ryder said that that's not satisfactory. Particularly retrospectively. You know, you're looking back and saying, well, did everything go okay? I mean, to what extent have you absorbed the manner in which Dr. Kumar has reached his conclusion and how that might have impacted on those questions? What kind of different questions might have been asked had you been aware of the capacity issues?
Is it sufficient for your case if we conclude that we cannot predict that the outcome would have been the same had a different approach been taken?
Absolutely. Absolutely.
You don't have to go higher than that.
My Lord, absolutely. The extent to which this court finds that capacity was a real issue in January 2021 and had it been known then, would have had a bearing on the issues before the court, would have been material. That's the end of the inquiry in my submission. The court certainly doesn't have to go on to say, and it's inevitable the ultimate outcome would have been different. And one can see immediately how dangerous that would be as an exercise. For some of the reasons that are demonstrated in my submission by this analysis carried out by the Deputy District Judge. So there was then the application for permission to appeal against the January decision and indeed the set-aside decision, which is page 102 in the core bundle. And for completeness, I'm not going to take you through that just now because I don't think it's necessary to do so. That application for permission to appeal did tackle both decisions, the set-aside decision and the substantive decision. And at that point, the certificate and the report was provided. It's not clear to me that the report was actually provided to the Deputy Judge King when she made her refusal of the set-aside decision. I believe it was only the capacity report.
The certificate?
The certificate, yes. The certificate was provided. I don't believe the report was. Permission to appeal was then refused by the first-tier tribunal. It's the same judge, District Judge King, and we see that page 100 and 101. And the reasons for that refusal are the appeal itself is made out of time. We then see the application for permission to appeal that's made to the tribunal itself, the upper tribunal, I should say, behind tab 11.
Sorry, page number.
Doesn't have
82. Apologies. Now, the change that's happened in the interim is that GT Stewart now have finally obtained some legal aid to assist with the housing benefit issues, and council was instructed, and grounds are drafted, which we see the substantive grounds begin on page 97. Mistake of fact leading to unfairness. Preceding that are the grounds in relation to delay, which I don't believe at this stage, at least, I need to take you through, because ultimately those submissions are accepted by the upper tribunal Judge Church who granted permission to appeal to the upper tribunal. That's behind tab 10, page 79, the core bundle. The extension of time dealt with under heading A and then heading D for substantive grounds. And as we know by now, having instructed counsel, the appeal is put on the basis of mistake or ignorance of a relevant fact, namely the lack of capacity of the appellant at the material time. And we see that accurately set out by Judge Church at paragraph 11. And then paragraph 12 explains further the reasons and addresses the materiality question. And frankly, paragraphs 11 and 12 reflect the appellant's submissions to you today. This is how we submit the case ought to be properly analysed. That the first tier tribunal judge's finding that it would have been relatively straightforward and a simple matter to show that her son did not reside at the property was based on a mistake as to your capacity to use or weigh information in the context of conducting these proceedings. The first tier tribunal drew an adverse inference from your failure to produce the satisfactory evidence that it had indicated would be straightforward to provide, and it is argued that this inference went to the heart of the decision on your appeal. I'm persuaded that it's arguable that the first tier tribunal was mistaken as to your capacity to conduct your appeal, and if it was so mistaken, such mistake may have been material in the sense that, had it not been made, the first tier tribunal's conduct of the proceedings and the ultimate outcome of the appeal might have been different. And that's precisely what we say here. Conduct in terms of steps that would have been taken to address the lack of capacity or the particular presentation of this litigant in person to address those anxieties and concerns addressed by Dr. Kumar, and then ultimately the decision on the appeal, because in terms of inferences, for example, or any other conclusions, they all would have had to have been made with sound knowledge of Dr. Kumar's opinion, and of course, potentially, the benefit of having other witnesses or others to assist her, because as we'll come on to see, but it's common ground between us, but whilst it's not always necessary for the tribunal to appoint a litigation friend for somebody who lacks capacity, it would normally be necessary to do something to assist them, to help them participate fully in the proceedings. And that can be in the form of a number of other types of representative. And the tribunal would be working with the appellant to identify such a person. Ultimately, it's a litigation friend now, but it may have been the same person. But it would have been somebody who would have been able to assist her obtain the evidence that she needed, etc., and overcome the lack of capacity that she otherwise presented with. So we then have the decision under challenge. That now to my skeleton, if I may.
It's really paragraphs 16 to 22, isn't it?
It is indeed, my lord, yes. So, as I've already foreshadowed, I of course acknowledge that Dr. Kumar doesn't explicitly state that there was a lack of capacity in January 2021. But when one looks to the findings of the upper tribunal, it's my submission that the finding that she didn't lack capacity in January 2021 was not open to the tribunal judge for the reasons that we've set out in the skeleton. and they are initially under ground 2, as we expressed the case. I'll come on to the area of approach in due course. Keeping in mind that the only way in which you can read Dr. Kumar's report, absent, of course, the clear statement about lack of capacity in January 2028, is that the 2 conditions that he had identified as thought disorders were the cause of her lack of capacity, and in particular, as the learned upper tribunal judge recognises, the dissociative disorder is the one that he describes as being more on point, but that's the one that's causative of the relevant thought disorder, is something that Dr. Kumar tentatively notes possible evidence of her dissociative condition from around 2018. Well, he says approximately 2018, but it's not a tentative conclusion in the sense that he's on the balance probabilities finding that she has that condition for that period. And it is the only condition that explains the lack of capacity in November 2021.
I mean, the core point, as I understand this decision, is the judge takes it from E and the Home Secretary that for mistake as to existing fact to work, it has to be established, uncontentious and objectively verifiable. And the judge says, well, there's some reason to think there might be such a thing, but it's not established, uncontentious and objectively verifiable.
He does indeed, yes. And that, in my submission, wasn't open to him, because on any sensible view of Dr. Kumar's report, even absent an explicit contention, what possible reason is there for concluding that she didn't lack capacity only 10 months earlier, when he's looking at the very letter she's writing at the time, and he's already said that she's had the disorder for some 3 years prior to? One would expect something of substance to be in this analysis to demonstrate that, if you can put it this way, there's a strong presumption, surely, based on Dr. Kumar's report. He hasn't been asked a question, so he's not said no. But had he been asked a question, the answer's obvious.
Well, I had this in mind when ordering the rolled-up hearing.
Yes.
Paragraph 3, if so advised, the respondent may submit medical evidence in response to that of Dr. Kumar.
Yes.
Which has not been done.
No, in fact, what's happened is we've got the evidence from Dr. Kumar clarifying without any doubt.
But you've got it before I made the order. Kumar 2 is July 24th.
Is that pre the order? I'm terribly sorry if that's the case.
I know it was a long time ago, but in fact it was only January 25.
I'm terribly sorry.
I know I took a long time to make the order too, but it was in January 25.
Yes, now I understand, of course, that my learned friend objects to me relying on Kumar number 2. And of course I have to address you on that. But I don't want to ignore the fact that Kumar number 1, in my view, can only really be read in one sensible way, that on balance, she lacked capacity in January 2021 because the evidence that supports the conclusion that she lacked it in November 2021 is present.
And Mr. Burton, you'll have an idea of how long
you're
going to take, but I am starting to think that...
Yes. Okay, so I have 2 other points really to cover.
Yep.
The first is where we say the learned upper tribunal judge went wrong in a sort of manifest way, which is that he concluded that the question of capacity couldn't be a relevant fact for the purposes of the E error of law criterion. It says you can't do that. You have to then focus on the finding of fact about it would have been relatively straightforward. And that, in my submission, does contaminate his reading. It's also wrong in my submission. But there is no authority on that, I have to accept. There's no authority either way, which says evidence as to capacity, which of course has a strong procedural component to it, as opposed to a finding of fact which goes to the substantive issues, can be a material fact for the purposes of the E jurisdiction.
But he doesn't say it can't be, does he? He just says it's not here established, uncontentious and objectively verifiable. Now, you'll obviously come onto the law. Do you accept that that's an appropriate test to apply in relation to capacity, or do you say it's not an appropriate test to apply in relation to capacity?
No, I do accept that, and I have to accept that. And I recognise that, we are, on behalf of the appellant, at risk on that point. If you're not with me, there aren't any sensible reading of Dr. Kumar's first report on the balance of probability, she lacked capacity in January 2021, and the upper tribunal should have found that, and its failure to find that is an error, then I lose on that point. But I then rely on the second report and Ladd versus Marshall as to why I say that this court should have regard to it nevertheless.
Yes, I follow. So at this stage, before you get the second report,
Yes.
the ground of appeal is it wasn't a conclusion open to this judge applying the test.
Insofar as he found, as he clearly does, that the appellant did not lack litigation capacity at the time of the hearing before the first day tribunal of January 2021, yes.
He doesn't actually find that. He says it's not an established, uncontentious, and objectively verifiable fact. Now, do you say that that was a conclusion that was not open to him?
Insofar as that is different from him reaching a conclusion that on the balance of probabilities having regard to the evidence before him, she did lack capacity.
Does he ever attempt to answer that question?
No, he doesn't. And I have to accept that he doesn't go on to that. He says it's arguable, which would suggest that he hasn't found on the balance of probabilities that it was so. And had he found it was so, then the mere fact Lambeth has said we don't accept it would have been neither here nor there in my submission. And the only things they rely on, incidentally, that he refers to for disputing that she might lack capacity in January 2021 is letters.
So just coming back to identify the dispute, you don't dispute that he was right to look for whether something was established, uncontentious and objectively verifiable.
Yes.
I think the core of your point is it was not open to him to conclude that this fact was not of that category.
Yes, because it wouldn't have been open to him to conclude on the balance of probabilities that she lacked capacity in January 2021. So can I put it this way? It was incumbent upon him, in order to reach the decision about whether or not the test was met for error of law in E, to first establish whether on the balance of probabilities it was correct or not that she lacked capacity in January 2021. Because without having done that, it's difficult for him to then properly analyse Lambeth's objection to that assertion.
But that seems arguably the wrong way round, because if the test is you have to look to see whether there is a fact that is established, uncontentious and objectively verifiable, well, why do you worry about what you would conclude on the balance of
For
probability?
this reason, that if there's an overwhelming body of evidence which suggests the alleged fact, mistaken or ignorant thereof, was true, and then you have a party saying we disagree that it's true, that of itself cannot be enough.
But then what you're saying is applying the test.
Yes.
The mere fact that somebody disagrees is not enough, which
Yes,
is a perfectly
absolutely.
intelligible position.
Yes.
But the substance of it is you're saying applying the right test, it was not open to the judge to conclude that it wasn't met.
That is the substance of it, yes. Where I've naturally attacked the judge's reasoning is to say it's merely arguable that she lacked capacity in January 2021 wasn't open to him on the basis of the evidence before him. He should have found that it wasn't just arguable, it was established at least on the balance of probabilities. Had he done that, in my submission, it's highly unlikely he would have then drawn the conclusion that, nevertheless, despite my finding, I'm going to find that the error of law is not made out because Lambeth has said they disagree. Because Lambeth have nothing upon which to form that disagreement.
I think I may be getting confused here.
I may be confusing you.
I think it may
clearly
be.
aware of that.
To my mind, I think it's simpler than this. Never mind, for a moment, leave E on one side.
Yes.
If the proper conclusion from the material in front of the upper tribunal was that she either did lack capacity or may have lacked capacity, why is it not sufficient to say that the fact that that was not taken into account by the first tier tribunal, for perfectly good reasons, renders the procedure unfair? Why is that not an adequate argument? Because if normally the rule in most jurisdictions is if you have material procedural unfairness, well, that's tautology, but if you have procedural unfairness, the only remedy that can deal with that is to set aside and start again. So at the moment, I'm not persuaded that this sort of analytical approach to E necessarily is the only answer.
My Lord, I entirely agree. And we preface that in our submissions by saying it may well be the appropriate way to look at all of this is a straightforward procedural irregularity. And my learned friend agrees with it, essentially. But it's also right to say that the error of law ground of appeal is the one that went before the judge below. It wasn't approached in the way that we say it should have been, partly because on the question of capacity, it wasn't considered to be capable of being a relevant fact. And you'll see that the problem with doing ground 2 first before ground 1 was what we're saying ought to have really happened is the court should have approached this on the premise that 21.3 applied or something similar to it. That if you reach the view that somebody lacked capacity at a material time, then that is clearly indicative of something having gone significantly wrong below.
Well, speaking entirely for myself, I think trying to argue by analogy to CPR 21 is really difficult.
Okay. Well, only in the sense that if you're presented with a situation where the evidence, and let's assume for a moment the evidence is so strong that you can't resist the conclusion that it amounts to a lack of capacity in January 2021, the consequences that flow from that are the very consequences that haven't been set out clearly in the context of the tribunal.
Yes, but as a matter of principle,
yes,
the difference between the position of the CPR and the position in the tribunal should be that if you've got a procedural irregularity, that's not enough. You've got to prove materiality or unfairness. And that is different from the default position under CPR 21, or arguably different.
I'm not sure that's quite right, because if the court is invited to make an order regularising steps taken previously when there wasn't a litigation trend, those are the very same fairness considerations that the court would look at. That's the Dunlop case. So the substance
in a
of the
CPR
exercise,
context, you mean?
yes.
It's pretty hard, actually, isn't it, to regularise things in a CPR context where there was a lack of capacity.
It is indeed, but it is, and I accept that's partly a reflection of the fact that you're dealing with adversarial proceedings almost by definition in that context, and here we're dealing with inquisitorial. But it's counterintuitive.
And acknowledged more flexible.
Yes, indeed.
So to protect the tribunal, who don't have the advantage in this sense of an adversarial position,
no.
The tribunal's got to be satisfied that it matters.
Yes.
And therefore, just to say there's a procedural irregularity, should have found lack of capacity, wouldn't be enough if the next sentence was, yes, okay, she didn't have she lacked capacity or may have lacked capacity, but it made absolutely no difference.
And indeed, that's what the authorities say, and I entirely agree with that. And of course, our cases here absolutely did make a difference. For the
I understand that.
I mean, our case is much more about the difference it made than the high hurdle.
I don't think you need to press that point. Whether it's a good point or a bad point, we understand that.
Grateful. To some extent, in the absence of an equivalent to 21.3, we have tried to force this appeal, also in light of the refusal of the set-aside application, to force this appeal through the only ground of appeal that seemed available when you're not criticising the tribunal below, which we are not. And we're attempting to have this unfair finding overturned on the basis of evidence that has only come to light since. And that evidence happens to relate to not a substantive issue, not brand new evidence about whether son was living or not, but actually really about the inability of this applicant to conduct those proceedings in such a way that they were fair.
But Kumar 1 and certificate are in.
Indeed. If Kumar 1 and the certificate aren't enough re-E, for the reasons that my Lord Justice Newey has highlighted, where do I go from here? I'm still left with this argument that something very wrong happened below. And standing here now, we all know we've got a very well-established psychiatrist telling us she did lack capacity in January 2021. There can be no doubt about that as we're standing here today. So my only way out of the problem that my Lord Justice Newey has presented me with, which I acknowledge as a problem, is to say, well, in Ladd versus Marshall principles, you can let in number 2, Kumar number 2.
Or because Ladd and Marshall doesn't strictly apply and it should be let in anyway.
Indeed. But I'm happy to approach it on the basis that Ladd versus Marshall does apply with the caveat about exceptional circumstances, because I say this case is exceptional. And that was the second of the 2 points I still needed to address, Your Honour.
Yes.
This is it. I'm very well aware.
So you say, if you get in Kumar 2,
Yes.
then at that point it really has to be accepted that there's an established, objectively verifiable whatever fact,
Yes.
and it's straightforward.
And the simplest way of addressing what's before you now, and I appreciate that it's not coming to you in the clearest possible terms, is to look at those exceptional circumstances and say we are entitled and will have regard to Kumar number 2, and at that point there can't be any serious argument about there being an unfair error of law if you're with me on materiality, which I would hope is the easiest thing for me to establish for various reasons. What I would like then to do, and it may be this is enough for me today, at least before you hear from my learned friend, is just take you to what's said about Ladd versus Marshall in E itself.
So we should go to the authorities bundle.
Indeed, where I'm going to try and go with some.
We've done well. We've avoided going to the authorities until 12.
Well, that's partly. Yes, well, it's the side benefits of my
No, I approve of this.
failure.
I approve this, Mr. Cooper. It's not a criticism.
So E begins at page 109. I mean, the big reveal, of course, is that E doesn't say in the context of tribunal proceedings that Ladd versus Marshall goes out the window. So I have to acknowledge that first and foremost. So let me be very clear about that. What I also think it's important to stress, however, for your purposes, in light of the conversation we've just had, and I'm just going to give you the reference for now, but I might need to come back to it, but my learned friend should be aware I'm relying on this, that the way in which the Court of Appeal articulated the error of law in E, mistake or ignorance of a relevant fact, is a species of unfairness, and procedural unfairness. And that's even without the additional component of it being about a capacity question. And as we've seen, capacity has implications both for process, how you conduct the proceedings, and indeed substantive findings. And we see that repeated in paragraph 61, which is the underlying principles too.
Where do you want to go to 61?
So, but I'm going to take you, to do with Ladd and Marshall, because that's really why I'm taking you to it just now. So, we see this beginning at paragraph 81 is where Lord Justice Carnwath, as he then was, reflects back on a judgment given in a case called Hiley's case, which was said to be an example of where the court found exceptional circumstances in relation to the Ladd versus Marshall principles, because there had clearly been an error by the representatives in not providing the material that was ultimately relied upon. So we see paragraph 79 in Hiley's case, crucial mistake, relevant, a substantive issue, of course, not procedural. Error was not drawn to the attention of the IAT. The evidence necessary to prove the mistake was first produced in the Court of Appeal. The error could and should have been spotted by the claimant's advisors before, nonetheless admitted. Accepted it would have fallen at the first hurdle, which is my learned friend's submission in relation to Kumar number 2. Effectively, we should have asked for an opinion about January 2021 when we asked for his first report. And then there's a discussion about how that issue is addressed, which is then picked up by Lord Justice Carnwath, as it then was at paragraph 81. It's actually saying, rejecting the idea that Ladd versus Marshall goes out the window, but you do need to apply it with some flexibility. that is then coined, as it were, in paragraph 82 as exceptional circumstances. And then Hiley's case is identified as an example of those exceptional circumstances. Then there's a discussion about a number of cases, speak to that, with the point made at paragraph 88. Something you won't be surprised to hear, but it's important to acknowledge that whether or not there are exceptional circumstances for Ladd versus Marshall principles is a fact-specific exercise. There's a limit to how much one can draw from other cases. Two further points. Just for completeness, although the extent to which I rely on this is obviously limited, but at paragraph 94, in the context of the present case, which they were disposing of, and the question of whether or not there had been a failure by the solicitor to effectively acquire the evidence beforehand, I can take it no higher than this, that there is a reference to the practical impediments of doing that and whether or not it's realistic. I'll explain why I'm taking
Practical
it to that.
realities. Practical realities.
Practical realities and realism. So those are the exceptional circumstances points, but I want to just take you to another two extracts from this in relation to Ladd versus Marshall. Just get this right. I could ask you to turn up paragraph 71
Of E.
of E. Now this is where there are considered to be exceptions to the general principle about courts not considering material that wasn't before the lower court, appellate courts I should say, and the acceptance by the Secretary of State that there are established exceptions to this principle. And I highlight the second of those. That where the jurisdiction of the tribunal depended on a question of fact, or where the question is whether essential procedural requirements were observed, evidence to establish the jurisdiction fact or procedural error is an acknowledged exception. And then we see subsequent reference to that again in paragraph 89, in reference to a case called Tator. And the last sentence of paragraph 89, in our view, the admission of evidence relating to a procedural issue of this kind, i.e. the second category in POIS that we were just looking at in paragraph 71, throws no light on the principles applicable to evidence relating to the substantive issues in the case. Now that's only relevant because that's a case where they didn't apply Ladd versus Marshall in that strict way, it being a procedural requirement. This is in the context of Lord Justice Carnwath, as he then was saying, no, Ladd Marshall does apply, but perhaps not in the context of procedural issues of this kind. So our submissions on Kumar number 2 is we do keep in mind, of course, that this is still very much in the tribunal context, but it's not only the tribunal context, it's a social entitlement chamber as opposed to the asylum and immigration chamber where typically people are unrepresented, whereas they are typically represented in the asylum and immigration appeals. So that of itself, and it's actually repeated in some of the UT decisions that we have before you, but I'm not going to take you to them just now, does require a softening, if we can put it that way, of at least the first element of Ladd versus Marshall, whether or not the evidence could have been obtained at the time of the relevant hearing. Second point is that this is a fact about capacity, which cannot be ignored. That's what renders this case exceptional more than anything else, at least in terms of the case law. Can't find any case where the question of a Ladd versus Marshall question arose at all, never mind an E question in relation to evidence as to capacity. So in my submission, that makes it unusual, if not exceptional. The third is that there is a very strong procedural element to this failure. One can see that what this is really about is whether or not the appellant had a fair hearing. And in my submission, you simply couldn't have had a fair hearing without understanding not only Dr. Kumar's conclusion, but the reasons for his conclusion, because they are so relevant to the findings made by the tribunal about why, despite having so many opportunities, the appellant didn't provide the material that she was asked to provide. The evidence itself is the form of an addendum to a report that we all agree can be admitted. An addendum produced in response to a finding made by the judge in order to address a point that was only said to be arguable on the basis of his report, but not conclusive. Well, we've made it conclusive now, but not without supported reasons. And indeed, Dr. Kumar saw the appellant for a second time before he produced Kumar number 2. Unrealistic, I put this only at this height, that at this stage, there's no legal aid for those representing the appellant in the overpayment proceedings. They've gone as far as to obtain the statements. They've gone as far as to get a report from Dr. Kumar. I appreciate that report may have had utility in the possession proceedings once they'd started, but the witness statements clearly didn't. They'd already gone above and beyond. To expect them to have also realised in advance, well, wait a minute, we better make sure this certificate doesn't just relate to these proceedings, but also has a specific component that addresses January 2021 as opposed to November 2021. It's not the sort of solicitor failure that one might ordinarily be dealing with when it comes to questions of these forms of relief and sanction, etc.
Can I just clarify in my own mind how this works? So your solicitors have legal aid for the possession proceedings.
Yes.
And they have legal aid for the present appeal, presumably.
Yes, but they didn't at the time they were obtaining Dr. Kumar's first report.
So that, and even now there is no legal aid for the underlying first-tier proceedings.
Unfortunately not.
Yep. And just...
And didn't have counsel, well, it didn't have solicitors until G.T. Stewart came on, and didn't have counsel at the time that Dr. Kumar was being instructed.
Didn't have counsel for 6 months after that.
And just helping me a stage further, when was a litigation friend first appointed? This was in the possession proceedings, or they accompanied the possession proceedings because they didn't exist?
No. So the litigation friend is identified for the first time on the application for permission to appeal to the upper tribunal, which was made in May 2022. But I believe she's identified at that point in the only box available, which is an appointee, which is it.
The certificate of suitability wasn't until April 24.
Exactly, yeah. So I think at that stage, because you can't actually have, well, you can have litigation friend in the tribunal proceedings, but the procedure's not established to do that. The individual who's now acting as litigation friend was identified as an appointee on the appeal to the upper tribunal. And it's fair for me to say has been assisting those instructing me since then.
So at the stage when...
Most great. I'm just getting the friend. So what's this one? Oh, it is from the upper tribunal application. My learned junior very correctly points out, I'm sure he's resisted many opportunities to do that so far. Page 83, that the individual is identified as the appointee, but then brackets are included, litigation friend.
And this,
Page 83 of what?
Page 83, sorry, of the core bundle, which is the supplementary bundle, which is the application for permission to... Is that core or something?
No, I think it is core, actually.
Core, I do apologise. Thank you.
So just thinking down it a moment longer, at the stage when Dr. Kumar's first report is commissioned,
yes,
your solicitors have concerns about capacity.
Yes.
They then get Dr. Kumar's report.
But actually, they'd already written to the tribunal before then. And
Mentioning that there was a concern about capacity. Right. When they get Dr. Kumar's report, they obviously continued to act.
Yes.
I suppose there wasn't much choice but to continue to act in the circumstances.
Yes.
Yes.
And they'd done the statements by then.
Yes.
But they didn't get any funding at all, such that council could be instructed or they could pay themselves for the work until, I believe, about April 2022. It's in the chronology.
Yes, I see.
So certainly they didn't have council's advice at that point saying, well, wait a minute, you need to go and get an expert report on this discrete question about January 2021.
Yeah.
And again, without labouring the point too much, when you've got a certificate and a report saying these conditions lead to a lack of capacity, the conditions have existed since 2018, it may have been felt that the inference to be drawn was so overwhelming, not least because the material used is contemporaneous, it's the letters.
What you're saying is, if this case had been being set up to go to the Supreme Court, it might have been done differently.
Yes.
If it had had absolutely top whiz-bang representation throughout. But that's not what we're talking about.
GT Stewart are not welfare benefit advisors. They're very explicit about that in their letters and indeed in the witness statement that accompanied the application for an extension of time. It would seem incredibly harsh to criticise them for not having obtained a further line in Dr. Kumar's report in November 2021. And indeed, in April 2024, it was I believe this court that prompted the request for a further certificate of capacity, which then led to Dr. Kumar producing a second report. And counsel at that point was able to say, can Dr. Kumar now address this question as well? For what it's worth, we also know that in his third report, comes not long after that, he also addresses the specific question about whether or not it would have been fair to say that it would have been relatively simple and straightforward for the appellant to comply with the request for information, and concludes that it wouldn't have been, for all the same reasons that he's concluded throughout his report. My Lords, I'm going to sit down now, but I just need to preface that by saying we do say that the upper tribunal judge did fall into error in saying, as he does in footnote 3, that capacity cannot be the relevant fact for a mistake of fact, error of law.
Can we just look again at what the footnote does say? So how far you take issue with what the judge says?
Well, the difficulty with it is that it may not matter for the reason that the judge does appear to accept that if he had found there was a lack of capacity in January 2021, his ultimate decision would have been different. I have to acknowledge that. But it's a question of principle, and in terms of how this issue is dealt with in the future, should it crop up again, there's obviously a broader question about whether or not we simply look at this as a question of procedural irregularity, which has enormous benefits, to be frank. But insofar as we don't, and we're left with the jurisdiction arising from E, then there is a legitimate question to ask about whether or not the upper tribunal judge is correct or not, which does have significant implications because it is a procedural question. It's not a substantive question, or at least it's quasi-procedural, even in the tribunal, because steps might have to be taken. And as we've seen, it can be problematic trying to understand the relevance of capacity in a straightforward way, which doesn't necessarily arise when you're dealing with a mistake of factual fact, if I can put it that, or substantive fact, as it were. But it does seem to me, at least in my submission, it's important that however the court ultimately wants to address these questions of the proper way of resolving an issue where a capacity question arises after the event, that something might need to be said about whether it's appropriate to rule out the possibility that capacity could be a material fact in that regard.
Can I feed into this, or try to feed into this, not where something arises after the event, but what the first tier tribunal should, on your case, actually do?
Yes.
So suppose you'd had an in-person hearing, the appellant had been there, the judge had seen the correspondence, which, well, perhaps you need to go rather further because the correspondence itself probably doesn't ring alarm bells. But suppose that the judge, hearing the appellant speak, answering or not answering questions, and thought, well, there's a question there.
Yeah.
What's a judge supposed to do about it?
Well, at the bare minimum, acknowledge it, which I think we don't even get to that stage, for all the reasons we've said. We're not criticising the tribunal for that. And in acknowledging it, one would have to acknowledge the reasons why one has the concern, however they are manifesting. And that may then have implications for the manner in which one conducts the proceedings. What I can't say, but I could turn my back on this, is what options are available to a tribunal unhappy, effectively, with somebody not being represented in front of them. What can they do in that situation?
I mean, I had a case myself, which didn't turn out very well, sitting in the High Court, where when I heard a litigant, a person speak, I thought, I'm not quite sure about capacity. And given CPR 21.3, I adjourned the case so that a medical report could be obtained. In fact, there was a lot of difficulty about obtaining the medical report. But in the first-tier tribunal, who would pay for the medical report? I mean, who would commission the medical report?
Well, the tribunal does also have access to medically qualified members who do sit on the social entitlement chamber quite a lot, because they often have to consider medical questions. So you could have done perhaps something around the composition of the tribunal, which I'm absolutely sure is within their case management powers. It could have directed Lambeth, for example, have a social worker conduct a capacity report on the appellant, because Lambeth social services do that routinely for people. They might have realised, as they would have a duty to, if it was outside their expertise, if it was a form of, or potential form of disorder that was too unusual for them to grapple with, they might have themselves had to have obtained medical evidence at the expense of Lambeth social services. But ultimately, the judge would have had to have been satisfied that, having been made aware of the actual reasons for the concern and having explored them, appropriate steps were taken, even before we get onto the question of whether or not it would have impacted upon findings.
So, sort of coming on to that stage, perhaps.
Yeah.
So suppose you have a situation where the judge says, says to himself or herself, I've seen the appellant, I do worry that there are concerns about capacity. But actually, here the evidence is absolutely overwhelming. It really doesn't matter that the appellant doesn't have representation and that there might be query as to whether the appellant really has proper command of things, because there's nothing that could be said.
Yes.
In that situation, for CPR purposes, you'd have to say, no, I can't do anything. What does the first-tier tribunal do?
Well, I'm not sure the analogy with what would happen in the CPR context necessarily follows, because strictly speaking, they might be able to do something.
Oh, well, all right. So perhaps I go further. Perhaps perhaps the judge concludes, I really don't think this person does have capacity. There's no medical report, but I don't think the person has capacity.
Yeah.
At that point, for CPR purposes, you say there's a real problem. Can the FTT say, well, no, actually, my role's inquisitorial, I can see that there's nothing that could be said, I can go ahead regardless?
So I've already, to some extent, the first point is that the scenario that my lord is positing strikes me as being hugely unlikely, that the evidence of the individual could be so obviously irrelevant that it can be effectively disregarded based on other material. And to be clear, we're nowhere near that in this case.
I'm not trying to comment on this case. I'm trying to understand the general principle.
Second, the duty of inquiry into relation to capacity applies to every court, including the tribunal. And there is support from that in the AM Afghanistan case, which is in your bundle behind tab 13, which we haven't come to, but I don't think it necessarily gives rise to anything controversial. The discharging of that obligation is one which would obviously be very fact-specific. But the wide powers available to the tribunal, case management powers, which again are in the regulations included in your bundle, but I can take you to those in due course if need be, include powers to direct that any party provide evidence on any particular issue. I'm going to fall a little short of saying that those powers would be sufficient to direct that Lambeth carry out some form of psychiatric assessment. But I certainly think they could invite Lambeth to do so and explain why they wouldn't be prepared to do that, keeping in mind that Lambeth's social services department is completely different from its housing department. And there may be other ways, for example, asking the applicant for permission to contact their doctor to ask questions. There's also a possibility, and I don't want to put too much weight on this, but you've got an example of it in the bundle in the case of SM, I believe, behind tab 19, where a judge is concerned about, an upper tribunal judge is concerned about whether or not findings in relation to medical issues were sound, was rebutted by his own inquiries he made by his own volition, and established that the first-tier tribunal had got something critically wrong about the medical diagnosis in relation to carpal tunnel syndrome, I believe. So there are a multitude of different powers available to a first-tier tribunal presented with material that might fall short of appointing a litigation friend. But at the backstop of all of that is the power, unequivocally, to appoint a litigation friend or some other form of representative. Do you have somebody who can come and speak on your behalf? Do you have somebody who can speak to other people on your behalf? Do you have somebody who can go and talk to your neighbours? Do you have somebody who can, you can see quite quickly that in that inquisitorial component there could be a dialogue. And to some extent that is what the first-tier tribunal did do here. They had a dialogue.
Bring
It'd
your
be
son.
helpful if your son could come.
Bring your son.
Yeah.
See if you can find these papers.
I have no idea if during the hearing on 21st of January anybody said to him, why didn't you bring your son? I have no idea. But I also can't say, and none of us can say, what might have been different had that interaction happened in person in the way that the interactions have happened with solicitors and Dr. Kumar.
Well, that comes back to what I put to you earlier, that we can't predict.
No. But Dr. Kumar, in his second report, explicitly says, I asked him, look, don't you think this is just a coincidence? Isn't it just a coincidence that the fact that you managed to get this debt relief order a couple of months before they started investigating, it's got nothing to do with each other. And you can read what response he got to that. So then you think, well, what would have happened if a first-tier tribunal judge had said, well, wait a minute, I mean, what if this is just, they're saying it's not connected. What evidence have you got it's connected? Rigidity in response might have sparked different sorts of alarms.
I've deferred your sitting
Yes.
down, but you've reached that point.
I think I should sit down now, yes. Unless I can assist any further at this stage.
Ms. McGibbon, it seems a bit silly for you to start for 5 minutes. Shall we start again at 5 to 2?
Yes, thank you.